Good morning, everyone. Just quickly, one housekeeping things we have. So we will be taking questions via Slido, and Erica has put in the information in the chat box. So please go to slido.com and enter the event code and choose Plenary Talk by Professor Ron Masulis, and you will be able to ask questions. And yeah, so I think we can get started. So I have the great pleasure of introducing Professor Ron Masulis as today's plenary speaker, and this is the third plenary talk in this session. And during his illustrious academic career, Professor Masulis has made fundamental contributions to our understanding of corporate governance. In a series of landmark studies, he has unfolded the role of independent directors in the business. More specifically, how financial incentives and characteristics of directors and CEOs affect firm performance and board decision making. Among his many achievements, he has one of the highest sustained rates of top-tier publications and frequency of citations across a range of top journals, including the Journal of Financial Economics, Journal of Finance, Review of Financial Studies, Journal of Accounting and Economics, and Journal of Law and Economics. He has received the 5 Journal of Financial Economics All-Star Paper Awards. He has served on the board of directors of the American Financial Association, the Western Finance Association, and the Financial Management Association. Professor Masulis also recently served on the board of directors of the Financial Intermediation Research Society. And he has served on the editorial boards of several top finance journals, such as Journal of Financial Economics, Journal of Finance, and Review of Financial Studies. His most recent research work and the topic of his talk today is how legal liabilities can affect a firm's ability to recruit high-quality directors with particular skills or experience. Please join me in welcoming Professor Masulis. You have 45 minutes for your presentation, and then we will open the floor for questions.
Okay, well, thank you very much.
Thank you.
Sagarita. I think you promised 2 minutes, but I think you went over your 2 minutes. Anyway, thank you for a very extensive introduction. I want to begin by noting that this particular talk is going to be more specific than the last 2, and probably I think Rena's is very much a bird's eye view of what's going on in corporate governance. I think John has taken a view that there's a lot of potential dangers in some of the recommendations that are floating around currently to change some of the landscape in corporate governance. I'm going to focus on boards of directors, who I think are still probably the most powerful corporate governance mechanism that exists. And I want to focus on both the question of legal liability and how that impacts directors, and various measures of director quality. And before I go any further, let me also just mention that this work is co-authored with 2 very talented researchers from Wuhan and University of Hong Kong, Sishen Chen and Hangzhou. Okay, just very quickly, director liability comes in basically 3 flavors. There are government and regulatory enforcement due to corporate violations of laws and regulations. There are shareholder derivative suits, which are suing to benefit the company, typically suing directors, 1 or more directors. And there are direct shareholder lawsuits, which are going to be primarily to the benefit of plaintiff shareholders, such as security class action suits. Now, director legal liability has a bunch of costs. They can be significant to directors. There are legal defense costs, there are time costs, their reputation, and potential cost and potential financial liabilities, generally associated with settling the suits. And on the other side, directors also have some legal protections. There are limited liability provisions in some corporate charters or bylaws. There is generally going to be director and officer insurance, D&O insurance. And then what we're going to study is universal demand laws, which generate partial protection from shareholder derivative suits. Now, the question of director protection against legal liability has been the subject of many rounds of debates in U.S. history. And in the interest of time, I won't go into the details of that. But one of the more recent rounds happened after the passage of SOX in 2002, where a number of experienced board members were very reluctant to join additional boards at a time when many corporations were in the need of more independent directors. Now, the basic dilemma in protecting directors from legal liability is the following. On the bright side, after you join the board, litigation and legal liability risk help discipline the managers, the directors, excuse me, and they help reduce agency problems because of that. On the dark side, liability risk is claimed to deter director candidates and to reduce a company's ability to hire top talent to their boards. And that's kind of the key question we're going to explore. Also, after joining the board, legal liability risks may make directors too conservative in their decision making. So there can also be a negative incentive effect. There's a bunch of related literature, but it's not directly related. Almost all the prior studies focus on incentive effects of D&O insurance protection. And most of these studies find an overall adverse incentive effect on firm performance. There's little research on the effects of legal protection on both recruiting or retaining outside directors. We could only find one study that even looked at the question, and they found no benefits. So our study seeks to fill this void in the literature by using staggered state adoptions of universal demand laws as exogenous shocks. Now, derivative lawsuits may not be something you're particularly familiar with, but they're brought against directors seeking potential recovery of losses that will be paid back to the firm itself. And the suits often are triggered by target M&A decisions, misreporting, failure to prevent certain forms of misconduct, excessive executive compensation, and insider trading. Now, the suits impose potential monetary costs. Obviously, there's also reputation costs and significant time and effort costs on the part of directors to prepare for these for this litigation. Now, there is corporate indemnifications, as I noted before, but they're available only for legal defense costs and not for settlements or damage awards. And even then, there's a clawback feature that says that if the directors fail to behave with good faith, then they have to return those payments. Now, in addition to the positive side of these suits, there are also many suits that are frivolous and are primarily primarily there to benefit the plaintiff lawyers And there's also a further set of derivative suits that are brought by activist investors with their own agendas, which are likely to deviate significantly from shareholders. I might also note that in many cases there can be both class action suits and derivative suits that could be going on simultaneously. Now, the effects of the universal demand laws are that they set a very high legal barrier before shareholders are allowed to sue one or more directors. And in particular, they have to receive board support for the suit unless they can show that seeking board approval may result in irreparable harm to the firms. Now, there are 23 states that passed UD laws between 1989 and 2005. And in one study, recent study that looked at some of these issues, APEL shows that the number of derivative suits dropped by about 40% after the adoption of these UD laws. Now, we're going to have two basic hypotheses for firms incorporated in states that adopt UD laws. Our first hypothesis is that there's a talent attraction hypothesis that predicts that after adoption, the quality of nominated outside directors should improve. And the second hypothesis, the talent retention hypothesis, predicts that after the UD law adoptions, existing talented outside directors should exhibit lower turnover. And then there are null versions of those two hypotheses that suggest that there will be no effects from the UD laws. Now, just to preview our basic results, we find that increased director protection after adoption of these laws helps boards to attract outside directors with more experience and higher reputation, but we find much weaker evidence that they're able to attract directors with better credentials, primarily educational, financial, legal. Now, the pattern that we find is much stronger for treatment firms that are subject to higher litigation risk. And the treatment firms will be those firms that are incorporated in states that adopt the UD law. So if a firm is subject to higher litigation risks because, say, the industry has more risk, or if they're facing smaller local pools of director candidates, then these laws seem to have more beneficial, stronger or more beneficial effects. Now, a couple of other interesting points. One is that the treatment firms tend to attract more high-quality directors from states that don't have UD law protection. And we find limited evidence that UD adoptions reduce the retention rate of high-quality directors in particular, but we find relatively strong evidence that they improve the retention rate of all outside directors. Now, our sample period is from 1986 through 2008. We start 3 years before the first state UD adoption, and we end 3 years after the last set of adoptions. And much of the information is coming from proxy statements, as well as some online sources. Now, in terms of data and properties, treatment firms must be incorporated in one of these 23 UD law adoption states, and we must have market capitalization data available on them. And we're going to exclude any firms that change state of incorporation within plus or minus 3 years. Control firms are going to be matched on firm size and industry, and they must be incorporated in states that are not that do not have UD laws, at least in the years that we're looking at them. And they have to meet the same data requirements. So we end up with about 375 match firms and treatment firms. Now, in terms of director quality measures, which is, I think, the other key element of our study, we look at 10 particular measures, and we divide them into two categories. And we calculate first principal components of the measures within each of these two categories. For the director experience category, we're going to include key senior executives and executives with multiple seats, where they might have, where they might be on the S&P 500, where they're are at firms that have significant amounts of patents. And we also are going to look at educational and professional backgrounds, and we're going to keep track of what degrees they have, whether they have an MBA, whether they have legal experience, financial experience, or industry experience. And then I might note, we also do some analysis of the individual director traits, but most of our analysis will be aggregating these traits into these two sets of 5 categories. Now, the model specification for director nominations that we're going to use is we're going to have our measure of director quality on the left-hand side, and then we will have indicators for firms that are incorporated in states that have passed UT laws by the prior year. And then we also have the controls for their headquarters state times fixed effects. In addition, we include large number of firm controls that you might expect might also be relevant. And we cluster our standard errors at the incorporation state level. Now, in terms of our baseline results, what we find is that there is a significant improvement in director experience if the state where the firm is incorporated has passed a UD law. As you can see, there's also a positive, small positive effect on their other credentials, but that is not significant in the baseline results. We also do some more dynamic difference in difference tests, where we can also test for parallel trends, which we find no evidence that they're violated in the year -1. And what we find is that after year -1, once the UD law is passed, we're finding in the next 4 years significant positive effects on firm experience. And this just gives you, highlights that pattern in the year-by-year results. Another interesting experiment that we run is to focus on the state of Pennsylvania, because unlike the other states that passed laws for universal demand, Pennsylvania actually was different. It had a judicial adoption of the universal demand provision, and that means that if you were worried about lobbying the legislature on the part of some firms incorporated in the state, maybe similar to some of the anti-takeover legislation that John has studied, then you would be concerned that for those firms that were lobbying, that this really wouldn't be an exogenous shock. But by studying judicial adoptions, this concern is avoided since these judicial decisions are basically free of lobbying concern. Now, what we find, as you'll see in the next table, is that the adoption has a significant positive impact, both on director experience and on its educational and professional background. Though as you can see, the results for educational and professional background, while significant, are roughly less than half the size for experience. But that gives us, I think, additional confidence in asserting that we are looking at a causal effect with these universal demand laws. Now, we also did some analysis, more in-depth analysis, looking for what types of firms have stronger or weaker effects. In particular, we were focused on varying pre-treatment litigation risk. And we looked at basically 3 indicators of low risk litigation risk. One being low M&A activity, which is often what triggers a derivative action suit. Low industry derivative suit activity, and firms in low-tech industries that face less investment risk and have less need for experienced directors. And what we found was that firms in the above 3 categories realized less UD benefits in terms of director experience, while the remaining firms that were in the higher categories realized greater benefits from universal demand adoption. Now, we also looked at whether having liability limiting provisions or protections in their charter or bylaws would also potentially undercut the effect of universal demand. But what we found was that there's only, well, first we note that there's only a limited amount of financial liability in the event of shareholder litigation. These protections don't cover legal costs, which are one of the major costs. Now, a key question is whether these protections that are already in place when the UT laws are implemented, complement or act as substitutes. And the basic finding that we have is that the beneficial effects of adoption on outside director experience is not impacted significantly by having these other protections. And this is consistent with many states adopting these provisions, even though they already had made it relatively easier to have liability limiting provisions in corporate charters in the states. Now, another question is there more of an effect of UT laws if you've got, say, shallow local pools of director candidates, or do you find that if they're large pools of local directors, that we get weaker effects from these laws? Now, we define a large local pool as being one where the pool is in the top tercile of the overall sample for that year. And we measure the pool by the number of non-financial S&P 1500 firms whose headquarters are within 100K radius of the firm's headquarters. And we exclude firms in the same industry, since they probably wouldn't be candidates that would be seriously considered. Now, what we found from looking at these various heterogeneous effects is that first, the universal demand laws significantly improve experience regardless of which sample you look at, but there is much weaker improvement in the case of low M&A activity and in the case of large director pools. In terms of robustness analysis, we also did some careful matching of firms where we paired them with close headquarter states or the same headquarter state, but the firm was incorporated outside the state. And what we found was that the results continued to be very strong, positive, and significant. Then the question we wanted to ask is, where are these high-quality director candidates coming from that are getting recruited to these UD adopting states? And so we use the percentage of nominated high-quality directors coming from a firm incorporated in a state without a UD law as our dependent variable. And what we found was that firms and states with these laws clearly attract more high-quality directors from states without them. And that's true both in terms of the experience characteristic, but also in terms of the educational and professional credentials that they have. Now, we also looked at the effects of UD adoptions on the retention of talented directors. And we did that using a similar specification to what we had before, but we're going to focus only on voluntary departures. So if they leave in the next year, that will be a voluntary departure. It can't be that they died, they were seriously sick, or they violated a law, or they accepted a position at a government agency. And we're going to use an indicator for low quality if the value of the outside director's composite quality metric is below the top tercile in the distribution. And what we found was that the likelihood of voluntary departures significantly went down, both in terms of experience and in terms of educational and professional background. But when we separated out the existing high-quality directors versus lower quality directors, what we found was that the effect was pretty equivalent across the two groups. So the retention effect is across virtually all outside directors, whereas the attraction effect is concentrated in directors who are more talented, especially in terms of experience. Now, in terms of a number of robustness checks that we pursued, we focused on, for instance, whether independent director quality would be different from what we found for all outside directors. And we found that they had very similar beneficial effects in terms of experience in the new appointments. We checked whether there was a SOX effect or a listing rule change effect, and we couldn't find anything there. We looked to see if increases in director compensation, which were trending up over this period, had any bearing, and we didn't find any evidence of that. We also looked to see whether there were confounding effects from other types of anti-takeover regulations that could be passed at the state level. And we found no evidence that that was driving our results. And we found that the results are robust to a simple aggregation of director quality rather than using the weighting schemes that we did for each of the 5 categories in the two groups. And the results were not affected by the 2008 financial crisis. The results, we also looked to see whether there was a regional economic set of patterns. And to do that, we looked at adjacent states or firms in the same state, but were incorporated elsewhere. And we found no evidence of that as well. So in conclusion, we examined the effects of state adoptions of these universal demand laws that significantly reduce derivative suits. We find that with more protection, legal protection, the quality of nominated outside directors measured by experience clearly improves. This effect is more pronounced for firms that are more likely to be sued or facing smaller supplies of local director candidates. Post-UD law adoption, firms incorporated in states, in UD states, are able to attract high-quality directors from states without these laws. And UD laws have less impact on other dimensions of director quality measured by education, financial, legal, and industry background, except when we look at the evidence for Pennsylvania, where there seems to be relatively similar results, or in cases where firms experience high litigation risk, where both dimensions are benefited. UT adoptions also lower the retention losses of high quality directors, but they do it pretty much equivalent to what happens to lower quality directors. So the incentives there seem to be pretty equivalent for the two groups. So in conclusion, our study addresses, I think, the current debate on the existing literature by validating the corporate concerns about recruiting high quality directors is a serious issue, and we contribute to the ongoing debate on the costs and benefits of director legal liability and protection, and explore a variety of different dimensions of director quality. Thanks very much. I can't hear you.
Thank you, Ron, for
Okay.
a very excellent presentation. I'm just now going to we are going to open the floor for questions, and I have a few questions here. So I'll just, sorry, can you please share the questions so that everybody can see them? Okay, all right. So the first question is from Praveen. So is there any specific reason, like why the economic significance of UDPEN variable in model 1 and 2 are much higher as compared to model 3 and 4? So this is a specific question on table 5 of what you presented.
Okay, well, maybe we should move back to that, see if we can find it. Let's see here. Table 5. Okay. Why do we find different results? Well, one, I think, reasonable possibility is that the more experienced directors are also more time constrained and are more sensitive to potential litigation time costs. And So they are more reluctant to participate on a board or join a board. There's a much wider potential pool of people with credentials who may or may not be as time constrained. So I think that's one of the likely reasons. It's also another possible partial explanation is that boards may have stronger preferences for recruiting directors who have significant experience, and that they may be particularly desirable for a variety of reasons in terms of benefiting them in terms of advice on various crises that might come up, various issues related to M&A or other types of major decisions the firm might make.
Okay, and we have the second question. So this question is from Terry, and he's asking, could you discuss the implications of your findings for non-US jurisdiction?
Well, we don't do tests for other, for boards in other countries. I think primarily because the data in the US is still, I think, much better and have much longer, typically longer time series. But I would expect that what we're seeing here is likely to generalize to certainly, I would think, a large number of other countries, especially common law countries and more developed countries. I may be more reluctant to argue that this would necessarily generalize to emerging markets.
Okay.
But that's just my conjecture at this stage, since we haven't tested it.
All right. So we have the third question. So it is again from Praveen. So he's asking, can insurance companies come up with the new idea of insuring directors' legal liability by charging a premium? This will certainly help firms to hire top talents to their boards.
Well, I mean, there currently exists fairly significant D&O insurance coverage. And most, say, S&P 1500 companies would be taking out this insurance coverage for their directors as well as their officers. So I guess the question is, what do you have in mind that might be over and above what's currently available?
Okay. So there is one other question. So it says demand requirements have long been developed through case law in the US. So would be useful to discuss what big changes the UD statutory law makes.
I think I didn't quite hear the question fully. Could you repeat it for me?
Yeah. Demand requirements have long been developed through case law in the US. Mm-hmm. Would it be useful to discuss what big changes the UD statutory law makes?
Makes for who, I guess.
Just
I'm kind of wondering what direction Pradeep has in mind for the effect of the UD laws.
Yeah, I think I don't know who asked the question because there is no name here, meaning if he or she can ask the follow-up question, so that way.
Just to clarify.
Yeah, because it's not very.
Yeah, I mean, currently, these UD laws are primarily pretty effective at significantly reducing derivative suits. They don't address other types of legal liability associated with, say, class action, shareholder class action suits.
So I think he meant changes to the case law. UD statutory law makes changes to the case law?
Well, I guess when it comes to adoption of these provisions, we only observed one state where the courts actually chose to adopt a UD provision, and once it's been adopted, or once the statute's been passed in the state, then generally case law will follow precedent and will continue to interpret the laws in a similar way, if that's what you have in mind.
Okay, I think we do not have any more questions. So I just would like to thank you again, Ron, for your excellent presentation. And I will pass on the floor to probably Bala to
Thanks very much.
Yeah, I mean, I don't have any question. I can only thank Ron for providing this outstanding service for Financial Market and Corporate Governance Conference. Ron is not there, and we don't have a conference. He's a strong supporter of a conference, and this is not the first one. This is not the second one. He is helping us, right?
I think it may be the third one, but it gets tricky to keep track of. John impresses me with his ability to keep track of the conferences he's attended, participated in. After a while, I struggled with that.
Yeah, that was just because Wellington was so amazing. I couldn't forget that.
Okay.
So thank you so much, Ron, for your participation and providing this keynote. Very valuable.
My pleasure.
So I need to stop there because I was in the background. I'm doing various things. So
sure.
It's
been a pleasure. I'm happy to be involved.
And we still have 10-15 minutes. I think that the panelists can talk to Ron. So feel free, unmute yourself, and just use this valuable opportunity to interact. And particularly, I don't know, John. So your last paper with Ron, maybe 2012 or maybe, yeah.
It's been a long time.
So, yes.
Yeah, something about these, the equity offerings and some,
Yeah.
thing.
I think it was
lock up, something.
Equity
right?
issues. Equity
Yeah,
issues.
yeah. So I remember that. So Terry, feel free if you're around. Hugh, feel free and interact. And just utilize these next 10 minutes fruitfully.
Can I ask a question, Ron, just
yes.
on the, so do you have any descriptive stats on, like, about the liabilities of directors, like what kind of liabilities they face? Meaning, I know you mentioned in the beginning, it's about financial reporting and then M&A activity and then, excess executive compensation. But other than that, like, do you have something like how often they face these liabilities and so on?
Well,
Meaning, I'm looking for numbers, basically.
Yeah, I don't have a set of figures in front of me, but it's probably a useful thing to add. I don't think we currently have it. But
yeah, especially those who have adopted those laws.
Yep.
And like the directors that they are hiring, and especially from the legal front, like how many, like, liabilities they have and so on, just to set the stage.
Well, let me just be clear. There was a study, I guess about 3-4 years ago, by Appel, who did look at the frequency change in the suits that were being made, and how it was affected by adoption of universal demand laws.
Mhm.
And he found a 40% reduction in the frequency of these suits. Now that's quite different from the question, what is the actual
Yeah.
legal liability?
Yeah.
And what we know is that there's been relatively few cases where individual directors have been actually hit with large, say, penalties or large awards that they had to pay.
Mm-hmm. Yeah.
Now
because
but I think our perspective is that while that's true, much of the costs that are borne by directors are non-financial. They're more the litigation costs, the time that you have to spend preparing for these various depositions and court hearings, and also in terms of the reputation damage that they can have.
Yeah, yeah, and I'm just thinking because when shareholder brings these legal thing against directors, I'm just thinking like how for a M&A activity they can bring against a particular or specific director, or a financial reporting they can bring it against a specific director. Winning executive compensation I can understand, but this one I'm just not very clear about.
Okay, well, for instance, in terms of M&A, you might have target directors who are being sued because they sold for too low a price, or you could have, say, acquiring directors who paid too high a price, or had some type of personal conflicts that might make their decisions non-objective.
Okay.
So that would be one example. You can have insider trading, which I think is pretty obvious that that could be an issue that could hurt at least some of your shareholders. And try to think what were some of the other ones that you were interested in.
The financial reporting one.
Financial reporting, I think, is probably, it could primarily go to the audit committee directors, primarily,
Yeah,
and maybe the chair of the audit committee as well, in particular. But a lot of them are likely to end up suing the entire board, at least the board that was in place at the time of the transaction that's being challenged.
Yeah. No, I think that makes sense. Yeah, I think that's all I have from my side. If anybody else has any question, they can ask.
Yeah, I'll throw something in. Hi, Ron. How are you?
Good. I don't see your video, but are you videoing?
Yeah, I've got my video on.
Ah, there you are. How you doing, Jerry?
I'm going well, thanks. The whole issue of who pays for these director liability insurance proposals is quite a controversial one. Should it be the director that pays from personal account, or should the director expect those liability insurance premiums to be refunded from the corporation?
I would think they would expect that the corporation would pay, because otherwise, how are you going to attract a director if those were significant premiums? Any rational candidate is going to ask themselves, okay, on the board, maybe I expect to receive $200,000 a year in fees, but now I have to pay my own D&O insurance, and that's $20,000 a year. So I would think you would basically deduct that from what you expected to receive from the company. And so I think it's probably simpler, and also it's more efficient to have the company contract for all the directors and pay for that insurance.
Yeah, and I understand that that's the way it's typically done, but it does raise a series of quite perverse incentives, it seems to me. If you're hired by a firm to do a job, and then in case you don't do that job well, the firm actually pays your insurance policy, that creates some quite severe disincentives, I think, for a director to perform his or her duties to the best of.
Yeah, I think you're assuming that the coverage is a lot better than it actually is. I think there's, if you can be shown to not be acting in good faith, I think the insurance company can basically not be required to pay on the policy, for instance. And I think, at least under current policies, they don't cover a lot of legal costs that might be there as well.
Well, let's just take that issue into our own domain, and that is the implications for researchers conducting research within universities. If that research was subsequently found to be fraudulent or subsequently found to be incorrect in its implications, people followed that, the implications of the research, suffered loss. Do you have a view on how that should all pan out within universities?
I would be strongly opposed to any legal liability because I think it would seriously undercut the attractiveness of Australian universities under those circumstances. I think normally if you're not being paid by the user of the research, then I think what kind of liability you should have, I think, is questionable. I mean, as long as, I think there's another issue about whether the university wants to take action against you. I would hope they would. But that's quite different from potentially creating legal liability, maybe by large corporations that followed that advice and now want to go after you. And there's the question of, well, maybe it wasn't fraudulent, maybe it was just poorly executed. If it was poorly executed, can the corporation sue you for giving them advice that turns out maybe to not be helpful? It seems to open up a pretty major set of issues that make, I would think, being a researcher a lot less attractive. And I think right now, one of the big challenges for Australia is to make sure that their universities continue to be attractive to researchers around the world. But significant cuts in tertiary education support and all these constraints in terms of special visa requirements are certainly not helping.